Hello, everyone. Thanks for coming in. We're just going to wait a couple more moments to allow the audience to come in from the waiting room. We'll get started momentarily. Okay, I think we can go ahead and get started. Hello, everyone, and welcome to today's episode of the EU webinar series on Europe and the world. I am Carrie Otterburn of the Leuven Center for Global Governance Studies, and I will be your host and moderator. Today, we are joined by Dr. Ingrid Landau, who will be discussing her new book, Human Rights, Due Diligence, and Labor Governance, which was published in 2023 by Oxford University Press. Ingrid is a senior lecturer in the Department of Business Law and Taxation at Monash University and a member of the Labor, Equality, and Human Rights Research Group. She is a socio-legal scholar whose research spans labor law, business and human rights, regulatory studies, and transnational governance. She has published widely in Australian and international journals and has undertaken research for the Australian Fair Work Commission, trade union and civil society organizations, and the International Labour Organization. Also joining us today as expert discussant is Professor James Harrison. James is a reader and associate professor in the School of Law at the University of Warwick. He is co-director of the Center for Human Rights in Practice. His research focuses on the broader social and environmental impacts of economic laws, processes, and actors. He has previously worked as a practicing solicitor and a researcher for a range of civil society organizations, as well as a consultant for several international organizations. We will begin today's webinar with a presentation by Ingrid of approximately 25 minutes. Then we will turn to James to kick off the discussion by offering some reflections and asking a few questions, to which Ingrid will have an opportunity to respond. Then we will turn to questions from the audience. So this is where you come in. Feel free to send questions for the speakers at any point during the webinar by using the webinar Q&A function at the bottom of the Zoom window. You should see it there at the bottom, a little button that says Q&A. I will collect your questions to share with the speakers during the Q&A session, which will follow the presentations. Before we begin, just a few words about the EU Renew project. The EU Research and Education Network on Europe and the World, or EU Renew, as we call it, is an Erasmus Jean Monnet network bringing together 19 higher education institutions from Europe, Asia, Africa, and the Americas, with the goal of improving knowledge and enhancing debate on the EU's role in an ever-changing world. Today's webinar is also co-organized with the Working Group on Human Rights and Sustainable Development of the World Bank Global Forum on Law, Justice, and Development. The Working Group explores the legal, policy, and operational links between human rights and sustainable development, with a focus on the Sustainable Development Goals in general and SDG 16 in particular. The Working Group is coordinated by the French Ministry for Europe and Foreign Affairs, the World Bank Human Rights, Inclusion, and Empowerment Umbrella Program, the World Bank Legal Vice Presidency, and the Leuven Center for Global Governance Studies of the University of Leuven. On behalf of EU Renew and the World Bank Global Forum on Law, Justice, and Development, I would like to thank Ingrid, James, and all of you in the audience today for joining us. And it is now my great pleasure to pass the floor to Ingrid. You have the floor.
Excellent. Thanks, Carrie. And thank you for the invitation to present as part of this webinar series. It's an honour to have this opportunity, and I'm really looking forward to the discussion today. I'd also like to take this opportunity to thank James in advance for kindly agreeing to act as an expert discussant, and indeed for reading my book. Much appreciated. Before I begin, I'd also like to acknowledge that I'm speaking to you today from the unceded lands of the Bunurong people of the Southeast Kulin Nation, and pay my respects to their elders past, present, and emerging. So my book that I'm talking about today essentially traces the ascension of the concept of human rights due diligence in transnational labour governance. It examines contests that have taken place since 2011 at global and national levels over the meaning of the concept. And it seeks to understand, what does the rise of human rights due diligence mean for the protection and promotion of labour rights in our global economy? I do have some slides, so I'll just throw them up. Now, just a moment, sorry. Nope. Okay. So in the brief time I have available, I want to I'll provide some background to the study, talk a little bit about what I do in the book and how I try and do it, and summarise the key findings. But I want to start today by taking you back more than a decade now, and specifically to 2010 and to the International Labour Conference of the International Labour Organization, the ILO. So I was at the ILC in 2010 in a former role as a legal kind of advisor at the Australian Council of Trade Unions and a worker member of the Australian delegation. And I remember running to attend a lunchtime presentation by Professor John Ruggie, who, as many of you would know, was the architect of the UN Guiding Principles on Business and Human Rights and coined the concept of human rights due diligence. You can see Ruggie addressing the ILO audience here in the photo on the left. So Ruggie had been invited by the ILO to discuss his work developing the UN Guiding Principles, and he chose to focus his comments largely on the notion of human rights due diligence. So I was struck at this gathering in 2010 by the promise that human rights due diligence held for labour, and also by, I guess, the breadth of support for the concept. In transnational labour governance, which is a field that has kind of long been beset with a lot of tensions and disagreements, it seemed remarkable that we had a concept here that was attracting such broad-based kind of support, and that promised to clarify many of the issues and resolve many of the issues in transnational labour governance. So in the following years after 2010, I was consistently struck by the apparent consensus around the concept of human rights due diligence and the high expectations that the labour movement in particular assigned to the concept, the international labour movement. Following the endorsement of the UN Guiding Principles in 2011, we saw the embrace of human rights due diligence in many other contexts. And I just have a couple of images on the screen to remind you of this. So in 2011, for example, the OECD revised its main instrument on corporate accountability, the OECD guidelines for multinational enterprises, and really kind of placed risk-based due diligence and the notion drawing on the concept of human rights due diligence at the centerpiece of its instrument. In 2015, following kind of the Rana Plaza disaster, shortly following the tragic collapse of the Rana Plaza building in Bangladesh, the G7 leaders met in Germany. And the German Chancellor at the time put the issue of working conditions in global supply chains on the agenda. And specifically, the G7 called for private enterprises to adopt human rights due diligence. We've seen many multinational enterprises revising their human rights policies and programs to at least use the language of human rights due diligence. And we've started to see the international trade union movement and human rights NGOs calling for binding instruments on human rights due diligence at the UN, at the ILO, and at the national level. So these developments were the impetus for my study. And the study, which kind of began in kind of 2015, so quite early in this process, essentially focuses on answering three research questions. The first is, how has human rights due diligence, kind of such a recent concept and one that's come from human rights rather than kind of labour regulation, emerged as such a dominant frame to conceptualise and operationalise business responsibility when it comes to workers' rights in global supply chains? How has the concept been able to garner broad-based support among actors in the global north? And finally, kind of the big one, what does the rise of human rights due diligence mean for transnational labour governance as a field of activism, policy and scholarship? So I want to just pause here and briefly explain two terms which may be less familiar to some members of the audience. The first is, of course, human rights due diligence. I imagine, particularly if many of you are in Europe, it's hard not to know what the concept is, but I want to just briefly kind of identify its main features. So human rights due diligence, HRDD, was introduced into the global lexicon through the UN Guiding Principles on Business and Human Rights, which is widely accepted as the most authoritative standard on business and human rights. So human rights due diligence is the way a business gives effect to its corporate responsibility to respect human rights. It is a process by which a business identifies and assesses actual and potential adverse human rights impacts, integrates and acts upon the findings, tracks the effectiveness of its responses, and communicates externally on these efforts. The process should cover the enterprise human rights impacts that an enterprise may cause or contribute to through its own activities, and those that it may be directly linked to through its operations, products, or services. So it requires companies, and this is one of the really appealing things about the concept, to look significantly beyond their own operations to working practices in their supply chains. It's under the UNGPs, human rights due diligence should cover at a minimum those rights in the International Bill of Human Rights and the 5 rights articulated in the ILO Declaration on Fundamental Principles and Rights at Work. So while informed by corporate human rights due diligence, the concept of human rights due diligence is unique. Okay, so the focus is on rights to focus is on risks to rights holders, not the company. It is an ongoing process, unlike transactional due diligence, and it should involve meaningful consultation with stakeholders. The second concept I want to briefly touch on before I move on is transnational labour governance. In the book, I use the term to describe transnational governance as a regulatory regime and as a socially constructed field of policy, law and activism. And I think conceptualising transnational labour governance as a semi-autonomous and socially constructed space, kind of an arena that brings together a number of different actors, often with different interests, ideologies, and so on, is kind of really key to understanding my arguments. So as a field, transnational labour governance is distinct from, but it certainly overlaps with business and human rights. And the field is kind of loosely networked, consisting of several centres that actively kind of monitor each other. And here in particular, we have geographically kind of centres in North America and Europe, and institutional centres in the ILO, the OECD, the UN, and so on. And so it's a field that's very crowded, you know, with international government organisations, IGOs, states, businesses, NGOs, unions, and a whole lot of for-profit actors as well. Okay, so that brings me, before I move on, I want to talk about the perspective I bring to transnational labour, to human rights due diligence in the book. My study is a socio-legal account of the rise of human rights due diligence, but it also seeks to understand the potential of the concept as a tool or mechanism of transnational labour law. And as I kind of articulate on this slide, a transnational labour law perspective brings its own unique set of concerns and approaches. And I think this is kind of important to emphasise because this is the perspective I bring to bear when evaluating the concept. And my conclusions may not be as kind of relevant or valid when it's considering other kind of subsets of human rights, which are not workers' rights. Okay, so this is briefly a slide in which I try to basically capture my study in 6 boxes. The boxes kind of roughly correspond to chapters in the book, and I want to touch on each of them very briefly. So the first thing I do is situate HRDD as an ascending but ambiguous norm in transnational labour governance. I argue that to understand the contests that have taken place over the concept, it is necessary to understand the landscape in which it was embedded. As I mentioned before, it's a really crowded and contested one. In this context, kind of the broad-based consensus that has surrounded HRDD initially appeared somewhat remarkable. But drawing on the kind of critiques of HRDD by other scholars, I've argued that the concept enjoyed broad-based support because it essentially sidestepped or stepped over a lot of the key and difficult issues. And it was a concept that was capable of being interpreted and operationalised in many different ways. So I argue that Professor John Ruggie secured support for the concept by using two devices that are long familiar to international international legal scholars, reframing and strategic ambiguity. So basically, human rights due diligence reframed kind of human rights in a way that was appealing and comfortingly familiar to business, but at the same time, it was kind of able to secure support from the international labour and human rights movement by the use of vague language and by not foreclosing lots of possibilities. Okay. So after situating human rights due diligence, I go on to conceptualise it at 3 different levels. And I argue that to understand what's happening, it's necessary to conceptualise human rights due diligence at the level of the enterprise as risk management, at the level of kind of the state as business regulation, and at the transnational level as an emerging and contested transnational norm. I'm going to just touch on each of these very briefly. It's important to understand human rights due diligence as risk management, I think, because it calls on business professionals to engage in a very kind of comfortingly familiar process of risk identification, assessment, prioritisation, and mitigation. As I mentioned, this kind of similarity to corporate due diligence is not a coincidence. It was kind of intended to be so. And in my book, I kind of draw on the critical risk literature, and in particular on the work of kind of Michael Power and Julia Black, to kind of discuss the way that conceptualizing human rights due diligence as risk management tends to lead to discussions of kind of labour rights as technical issues, and to be seen as issues that can be kind of can be objectively measured, that can be quantified and assessed, and that are kind of clear-cut and not contestable in the way that labour rights are generally politically so. I also discuss human rights due diligence as a form of business regulation, and I think this is really important, obviously, as we've seen in debates in recent years, to reveal the stakes that are kind of involved in contests over its legalisation, and the way kind of the different regulatory possibilities and the ways that laws that have come about in recent years have closed off some possibilities at the expense of others. Finally, I kind of conceptualise human rights due diligence as an emerging and contested transnational law. And here I kind of draw on the work of socio-legal scholars Terence Halliday and Gregory Schaefer that kind of emphasise the recursive and iterative nature of transnational norm making, the kind of the move from soft to hard law, the moves kind of from international, national and back regional and back up again, and emphasising the different actors involved in this process. My third box here, once I've established that, is to go on and explore how different actors understood the concept differently, particularly in the years following 2011, kind of up to in the 5 years or so following 2011. And I kind of argue that human rights due diligence has facilitated a shared discourse and language between groups with very disparate approaches, and that this kind of contribution of human rights due diligence is a significant one. But drawing on documentary analysis and interviews conducted at a range of different sites, I argue that the ambiguities in human rights due diligence have enabled kind of 2 different understandings of the concept to coexist. And here I draw on socio-legal concepts of legal endogeneity. So the notion that when actors are faced with ambiguous or uncertainty in legal rules, they tend to filter the concepts and resolve the ambiguities through their own distinct logics. And based on my research, I kind of, I identify two stylized logics when it comes to human rights due diligence. One is kind of what I call transnational labour-oriented one, and one is a business logic. And I've just kind of, on this slide, I kind of reproduced some of the differences, the significant differences in the implications of the concept when it's filtered through those two logics. Okay. So of course, the fact that there are different understandings of the concept isn't that significant. What's significant is, okay, so which of these understandings has kind of prevailed and how? So in my book, I look at kind of contests over what human rights due diligence means, what it requires of businesses and the state at the global level. And I look in particular at the two sites of the OECD and the ILO, and at the national and EU level. At the international level, I focus on two IGOs that have overlapping mandates with respect to transnational enterprises and labour standards, the OECD and the ILO. And I argue that the OECD has enthusiastically kind of embraced human rights due diligence in its work when it comes to, and in particular has been very active when it comes to labour rights in global supply chains. It's not only revised its key instruments on responsible business conduct, the OECD guidelines, but it's vigorously kind of pursued what it calls a proactive agenda to promote and elaborate on what human rights due diligence means generally, and in particular to certain sectors. And it's also tried to reinvigorate or strengthen its special instance procedure. And so I argue that the OECD's kind of working style and its kind of composition, its smaller composition, has enabled it to be much more nimble and to embrace human rights due diligence in a way that other organisations like the ILO, which are perhaps more democratic but more cumbersome, have not been able to do so. And I argue that the OECD is essentially deferred to what I've identified earlier as a managerial or business logic to human rights due diligence. And it's minimising, very much minimising the political nature of its activities in this area, and privileging the kind of notion that this is kind of objective and technical in nature. The ILO engagement with human rights due diligence has been much slower and more fraught. In part, this is kind of a reflection, I argue, of the ILO's traditional kind of antipathy towards corporate social responsibility initiatives. And it's also true and important to recognise that the ILO has done a lot of kind of work on labour rights in global supply chains that don't pertain to due diligence. But it was compelled to engage with the concept in particular when in 2016, certain constituents of the tripartite organisation, including workers and some member states, have sought to use the ILO as a forum through which to secure, I argue, a more robust transnational labour-oriented understanding of human rights due diligence. And I spend quite a lot of time in the book talking about the International Labour Conference in 2016, where the workers and some states really tried to make progress with respect to the ILO and human rights due diligence, and called for a mandatory standard, a binding international convention on the subject. However, these efforts by the labour movement and others to promote a more robust, inclusive and deliberative form of due diligence at the ILO were met with very strong opposition by employers' constituency. And while the employers, and I talk about this quite a lot in the book, have not objected to the ILO dealing with human rights due diligence per se, what they have done very successfully is resisted and constrained the organisation when it comes to standard setting on the subject. What business has done effectively is to encourage the ILO to adopt a role as in providing information and research, and as basically a source for business due diligence rather than a standard setter. So I conclude that the ILO is still, I think, struggling to find its role and voice with respect to human rights due diligence. I then, following that, go on to look at contests over the institutionalisation of human rights due diligence at the national level and at the regional level in the EU. In a number of jurisdictions, human rights due diligence has, of course, in the last couple of years, hardened into legal obligation, and this trend is very much continuing. I only have a chapter on this in the book, so it's very much kind of a more historical perspective rather than analysing current regulatory initiatives. But I characterise kind of two different approaches, which I see. The first is I characterise as statutory deference. So these are laws that effectively defer to business-oriented interpretations of human rights due diligence and to managerial prerogative. They leave a great deal of discretion for businesses to decide to what extent they engage in the practice and how they do so. And we find this first statutory deference approach basically in Anglo-Saxon liberal economies such as the US, the UK, and Australia. So these approaches generally consolidate a business-oriented interpretation of human rights due diligence and existing private labour governance approaches. The second approach, the statutory elaboration approach, is broader in scope in terms of the rights covered and imposes more substantive obligations on business. I suggest in the book, and I still probably think it's the case, it's too early to tell whether these obligations in these laws will be implemented in a manner that strengthens transnational labour law. So the last several chapters of my book pull together my findings and draw out their significance for labour activism and scholarship. First, I argue that there's really little to suggest that human rights due diligence is basically meeting the expectations that were accorded to it in its early years, but particularly by the international labour and human rights movement. It is not being legalised in ways that create novel and meaningful channels through which workers, their representatives and others can challenge existing and prevailing corporate approaches. It's not challenging existing business models in any way, and I think that's really important to note. To the extent that the concept has been successfully elaborated upon at the international level, this has been limited largely to the production of kind of information and guidance that fails to establish clear minimum standards. At the national level, human rights due diligence is generally being legalised in ways that very much narrow the concept, circumscribe its potential, and again tend to legitimise rather than challenge existing corporate practices and private labour governance approaches that have long been seen as problematic by not only the labour movement, by many scholars. So I argue that there's a real risk that human rights due diligence laws will in fact lend a technical, veneer, an apolitical veneer to questions which are deeply political around corporate accountability and labour rights. Okay, I then turn finally to examine, the implications of human rights due diligence ascension for transnational labour governance. Identify three trends that I think are really important. I think as socio-legal scholars have long reminded us, the ascension of a new idea or frame in a field can have far-reaching consequences for it can change the configuration of actors in the field, the tools they have at their disposal, and their tactics and strategies. I argue that the rise of human rights due diligence is influencing transnational labour governance in quite profound but largely underappreciated ways. And I talk about the great expansion of for-profit intermediaries. And here I referring to business consultancies, auditing firms, law firms, and so on in the field. Of course, these types of actors have always been present in transnational labour governance, but I really think that they've used the concept of human rights due diligence as a channel through which to really leverage their skills, their expertise in due diligence, and possibly at the expense of other actors. I argue that national courts are being positioned to assume a more active role in determining the nature and scope of corporate responsibility, and we see this role for the courts significant role for the courts in some of the human rights due diligence of the mandatory laws. I argue that there are kind of I have questions and concerns about this increasingly prominent role of courts. And in particular, I said kind of question the extent to which they will just simply defer to prevailing corporate practice. And finally, I talk about how the OECD has really kind of embracing and using the human rights due diligence as a kind of a point through which to significantly consolidate its position as the preeminent authority on corporate accountability and labour rights, at the expense, I argue, of the ILO. Okay, I just want to very briefly, before I finish, if I can, the final thing that I do, which is this last box, is essentially a bid to prompt further reflection and debate among scholars and activists. So I start the process of envisaging, well, if human rights due diligence on its current trajectory is not looking very promising, what's an alternative trajectory that we can start to discuss and identify a number of different ways which I think would help steer the concept towards an institutional and legal form that would open up rather than foreclose spaces for workers, unions and others to challenge corporate practices. I think that's about my 25 minutes, if not a little bit more. So thank you everyone for listening, and I'll pass over to James for comment.
Thank you very much, Ingrid, for this great overview of your book. It's absolutely fascinating. Now we'll obviously pass the floor to James, but I would like to also quickly remind the audience that you can send your questions for the speakers via the Q&A box at the bottom of the Zoom window. So please send your questions in and we will get to those after we hear from James. Over to you, James.
Thanks, Carrie. Thank you very much for the invitation and the opportunity to read this book, because I must say I really enjoyed it. And I agreed with most of it, so I'm probably not the best discussant. But I would encourage people to read it. I mean, if there are non-academics in the audience and you're generally put off from reading academic books, I'd say this is a fantastic book and very readable. I read it practically in one go, and it's written in a fantastic and engaging style. In terms of substance, my background's in labour governance and human rights, so it puts those two things together in a way that was fascinating to me. And I really enjoyed the socio-legal and empirical methods employed in the book. So I think a lot of human rights due diligence writing, including some of my own early work in this area, has focused on norms and processes. And what this book does, I think, is, to me, tells us that human rights due diligence is not just a text, not just a set of norms, but it's enacted and brought into being by various actors. And to me, this book is a tale of those kind of key actors who are vital in the process of enacting human rights due diligence. And it's full of analysis of the roles played by those actors. So corporate actors, trade unions, intergovernmental organizations, the OECD and the ILO, those for-profit intermediaries, judges, national authorities. And I think that's what makes the book really rich in telling us about the role of these key actors, when so much of the existing literature stops at the norms and processes of due diligence. So I thought I'd frame my comments by reference to three of those groups of actors that are discussed in the books, and have three questions that follow from discussion of those three actors. So first of all, the kind of intergovernmental organizations. So I really appreciated the detailed analysis of the role of the OECD and the ILO in relation to human rights due diligence, the story of why the OECD is successful and the ILO not successful in creating epistemic authority over the meaning of human rights due diligence. And I think the questions you raise about the opaqueness of practices at the OECD, the lack of transparency and accountability, are really important questions that I think should be studied in more detail in the future. So my question here is, I suppose, and this is my geeky question, I would have liked a bit more detailed analysis of the sort of sector-specific guidance that the OECD produced. And I was, you talk about hundreds of pages of guidance, but you don't spend much time actually talking about the substance of that guidance, other than telling us that it perpetuates the idea of corporate risk management. So I just wondered if you could say a bit more about the guidance produced by the OECD and the substance of that and what it contained. Second, I think there's a fantastic account of the role of for-profit intermediaries. So these law firms, consultancy firms that are going to be and already are advising companies on how to do human rights due diligence. So I've done some work on this in this area, kind of interviewing some of those actors who are doing that kind of advisory work at the moment, and my findings were very much in line with what you find in the book. So these firms will play an increasingly important role interpreting and implementing human rights due diligence initiatives, and the danger is that they replicate the problems of the kind of audit culture we find elsewhere, and we'll have kind of superficial practice being the kind of dominant form. So I suppose my question there was, how do we overcome some of these problems? And do you think there is a sense that we might create the kind of personality of in a way, the human rights due diligence professional, that we need to kind of professionalize that role and come up with some kind of professional ethics and question and issues of how that practice looks? If those actors are going to be so important I think you're absolutely right, in the process of how human rights due diligence gets translated into corporate practice. What can we say? What are the actions that can be taken to kind of protect that role from the kind of superficiality that might be driven by some of the kind of for-profit motives that are going to be driving the big firms who are kind of entering this field? So that was my second question. And then the third set of actors, I think, were really interestingly discussed in the book, were the kind of judges and supervisory authorities. And I really appreciated the way you identified the limits of the role judges were likely to play. I think sometimes the debate around human rights due diligence can just be about how to make it actionable in courts. And I think by raising the potential for judicial deference, and so the limited roles that courts might play, I think that's a real call to look beyond just making human rights due diligence sort of actionable in courts as the kind of end goal of activism in this area. Certainly, I mean, we have an example in the UK, the Equalities Act, which looks very similar in process to the due diligence processes we find internationally now being adopted. And there's been a story of judicial deference over time. These kind of process-orientated obligations on, in this case, public authorities in the UK look very similar to the process-orientated obligations created by human rights due diligence law. We found judges over time really just saying to the actors, you've got to have a process in place, you've got to consult, you've got to report, but going very, very little beyond that to kind of impose substantive obligations. And I think you're absolutely right in pointing out the likelihood of that happening potentially with judges. And so I thought you did some really nice work to identify the crucial role of national authorities to ensure businesses take their responsibilities seriously. And I agree completely with your ideas that resourcing, independence, expertise of these agencies is absolutely crucial. I suppose then I wanted to push you on almost the most fundamental question. And I took in your talk as being a bit more pessimistic, but in the book a bit more optimistic, right, about the future potential of due diligence. So kind of my question really is, are supervisory authorities capable of playing a kind of meaningful role to scrutinize the due diligence process that's undertaken by corporates? And just to give that a little bit of context before I finished. So, I agree with you that human rights due diligence is very broad and that companies are in charge of the process and they have lots of discretion in terms of their prioritization processes and the assessment processes that they enact. Supervisory authorities in all the laws you looked at are in charge with regard to supervising the process. So, making sure there's a policy in place, making sure assessment happens, making sure potentially there's a complaints process, et cetera, et cetera. I suppose, how will they engage with the substance of what corporates produce is my question. I know you've got a right to information and a right to consultation that you put forward as ways in which we can kind of make human rights due diligence potentially more progressive. But I suppose my question around the supervisory agencies is they don't seem like they're tasked with creating their own repositories of knowledge around corporate human rights behavior. So, or data by which they can judge whether the substance of corporate human rights reporting is appropriate. And I suppose I wanted to contrast a little bit with the more specific due diligence laws on issues like forced labor, on deforestation, or batteries and other things that have been produced by the EU, where regulatory authorities will have their own kind of degree of independent information on forced labor risks, deforestation risks, critical mineral risks, etc. And so I wondered whether, fundamentally, have we got something that's just too broad and too process driven to be capable of kind of effective supervision by supervisory authorities in terms of generalized human rights due diligence, or can supervisory agencies play a meaningful role in relation to human rights due diligence with the kind of safeguards and additional elements that you suggest should be put in place in the book? But overall, I thought fantastic. Really, really enjoyed it, and these questions are really just sort of taking you further and beyond the book to ask sort of questions on top of that.
Thank you very much, James, for these questions. And we'll pass it right over to you, Ingrid, for your response, and then we will turn to the Q&A with the audience shortly after.
Okay. Well, thank you, James, very much for the comments. And I'm really pleased that you mentioned it is actually readable. I remember kind of when I shifted to academia, kind of in my 30s, I swore that I would be an academic who actually produced stuff that could be read, and that was kind of hopefully useful. So I'm glad that that seems to be the case. The three kind of sets of questions or comments you had are all kind of really good ones. And I guess my short answer is I want to do more research on all of them, which is kind of, I think, one of the fascinating things about human rights due diligence is there's just so many questions that are unanswered. And I'm kind of really hoping that the literature will go beyond, simply comparing what are the different features of the different laws on paper to kind of answering some of these more kind of questions about its impact and how it's being used and so on. On the international governance, the IGOs and the role of the OECD, again, it's kind of an area that I'm trying to do more work because I do think it's really important, and I do think there is a kind of a real, though there has been some work from Labour scholars, which is great. I think there's an area where there could be a lot more. One of the kind of the questions that you raise is around the sector-specific guidance, and you're right, I don't look in that, and I haven't looked in great detail at those documents. I think that they're really fascinating for the way that they were produced, which is very hard to even find out about. Some of them were produced by working parties, which may have involved, as I understand it, actually kind of representatives from certain multinational enterprises, but the membership of those working parties is not available. And I find that from a kind of public lawmaking perspective, problematic. And especially when we consider that, national laws are kind of increasingly referring to and using those OECD guidance documents, which I struggle to get my head around. These documents do not set minimum standards. So it's very hard to then propose that you have a regulator evaluate compliance with them, because they are not documents that, as you mentioned, they're very detailed kind of documents. And they often contain this kind of, like, business could do this, or a business could do that, which is not very helpful, I don't think. So I do think there is kind of certainly role for more kind of research, and I guess more writing on how are these guidance documents that are becoming very significant in particular sectors and broadly and widely used, how are they developed, and how are they, I guess, and how are they being used by states and other actors? On the intermediaries, there's some great work by Genevieve LeBaron and others on the role of intermediaries in the UK context. I think there's really important questions around their business models. How are they marketing and packaging their human rights due diligence services? Because often they kind of package a little bit, and then they try and sell more. So, how is all this influencing how human rights due diligence is being done by businesses? I think there's really important questions which you kind of raise around public frameworks for these intermediary actors. And in intermediaries, you can also, I guess, throw in some of the private kind of business-led multi-stakeholder initiatives, and, again, these are kind of being I guess, being given a kind of privileged position in some human rights due diligence laws, and questions around, well, how is the state going to kind of, I guess, regulate the quality, if at all? And fascinatingly, I think you see the OECD starting to move on this, benchmarking MSIs and giving some guidance on intermediaries and so on. So I think, again, that's a really interesting space to watch. And the OECD, as it tends to, kind of being very nimble in filling that space. I like the idea of a professional, HRDD professional. I'm not sure. I'd have to give more thought to how that would work, but it's a fascinating concept. On the third one, very briefly, was the role of courts. I do recognise that I think perhaps more so than other areas, the role of courts does have cultural, kind of national and cultural differences. Like I see, particularly in the French context, the advocates feel very strongly that the courts should have a very major role. And indeed, civil society has said in the past, we don't want a regulatory authority, we want the courts. That is, I think, very different to perhaps the Australian context where, labour rights activists kind of see the courts as, they're necessary, but they're certainly not the first place you'd want to go, and privileging kind of negotiated solutions and other kind of an active regulatory authority over the judicial kind of resolution of disputes. So I do think that kind of, and that would be a really interesting research on its own, I think, the different role of courts in these processes. On the regulatory authorities, I have to say, watch this space. With a colleague, Shelley Marshall, and I have done some work recently on, I guess, what an ILO instrument on human rights due diligence would look like. But part of that included what would be, that we saw would be the kind of the ideal role and powers and resourcing of a national regulatory authority. So we've tried to put kind of thought into drawing, quite a bit on the EU kind of directive, because that was, at least in its draft form, kind of quite strong in this area, but looking at what would be some of the minimum kind of standards at the international level that could be used to inform how ILO member states perhaps establish and fund and empower their HRDD regulatory authorities. So I'm happy to share that work and for anyone who's interested. I think that's it. I'll just open it up. I realise we're running out of time. Apologies for taking up so much time.
No worries at all. Thank you very much for this discussion. I think we'll continue it now with bringing in some questions from the audience. We'll start with 3 questions, if that's all right. First question, first audience member would like to know whether there is a tension between the definitional openness required for building a broad societal coalition around human rights and the need to articulate safe or maybe narrow definitions of human rights that businesses do not feel threatened by. Then the second question is, since human rights due diligence is not being institutionalized in a transformative way, what would you propose as a better and more robust alternative? Some of us are working on a way to right the economy, so to speak, to put human rights front and center. Is this realistic based on your empirical knowledge? And then a third question is wondering more about the future and a bit about the different scope of the different laws that are coming out. There's a lot of variation between different laws. Some due diligence laws are specific, focusing on forced labor or child labor, and others are more comprehensive, covering a wide range of human rights. Do you expect that there will be a difference in impact depending on this scope of laws? We'll start with those for now.
Okay, they're all great questions. Okay, the tension between, I guess the first question, I'm not sure if I understood it properly, framing a tension between kind of a broad, robust understanding of human rights and framing it in a way that doesn't threaten isn't seen as too threatening to business. Is that?
I think it's asking about the tension between an open and broad understanding of human rights, more, I guess, for the protection of human rights, and then also more of a business making a definition of human rights that's a bit more narrow, and maybe more business friendly.
Yeah. Well, I guess I think you know, like many others, I think the UN Guiding Principles did that kind of quite well. They, you know, clarified the different roles, I guess, of the state and business with respect to human rights, and I don't even think that the concept of human rights due diligence is too, I guess, business friendly. But I think one of the really important things to recognise is that human rights due diligence in its original form was a kind of a very small piece of a much larger picture, you know, and sometimes I think we kind of, I guess, we lose that. And the much bigger picture is the kind of the promise of a broader, I guess, more substantive approach to these issues. And I think, you know, for I'm not sure if it's conscious effort, but certainly human rights due diligence is kind of shot out on its own at the expense of other equally, if not more, valid and important concepts in the UN Guiding Principles. On the second question, what is a more robust alternative? I guess I take a fairly pragmatic view on this, maybe 5 years in a business school now. But I think there's, on one hand, I think, you know, certainly there's no point in abandoning human rights due diligence. It's there to stay, and we should be trying to think about crafting due diligence regulations and regulatory infrastructures just as importantly that try and make a more robust human rights due diligence. But of course, I also think it's really important that the focus on human rights due diligence doesn't take away from other alternative approaches, which are, you know, as valid or certainly more valid and effective. And here I talk in the book about transnational industrial relations agreements, TIRAs, or, you know, there are other words for them, but things like the Bangladesh Accord, which kind of, and if other agreements on kind of living wage and so on, which are kind of negotiated solutions, which have a lot more kind of monitoring, worker-driven monitoring effects in them. So I think certainly there are, you know, other approaches, and we need to be really careful that our focus on human rights due diligence is not detracting or kind of making us forget about those other approaches. Thirdly, on the scope of the different laws, look, I mean, I'm not sure about impact because it's hard to, the narrow versus broad scope in terms of human rights. I do, and I've written on this, I do have a concern that, for example, in the Australian context, our laws that focus on modern slavery have the effect of, I guess, you know, diminishing corporate attention that is paid to other equally, if not more, kind of pressing human rights, labour rights issues. I think the extent to which one of the fascinating areas of human rights due diligence is how businesses prioritise their risks that they're focusing on and addressing. I think that's a kind of a really important space, and a space where there's a lot of slippage and a lot of the kind of meaning of the concept can be lost. So I think rather than, you know, I guess the broad or the narrow, it's those kind of more intricate kind of questions around how they're being implemented by business that are probably more important at this stage. Yeah. I'm not sure if I answered any of the questions, but I gave it a go.
I think that's great. I think we have time for maybe 1 or 2 more questions, if that's okay. First, how have workers and unions sort of been responding to human rights due diligence, and how are they using it to frame their claims against employers already in judicial or non-judicial fora? And then back to the role of courts, you already discussed this a bit, but have there already been some examples of judges or courts' involvement in interpreting the boundaries of businesses' responsibilities vis-a-vis human rights due diligence, and especially with regard to workers' rights? And if there are, if you could comment on that. So maybe we'll go with those 2 for now.
Okay. they're both, I feel like everyone's just identifying questions that need to be answered, by that they have not, as far as I know, been answered by anyone, though I might be mistaken, but are really important questions. I say in my book that, you know, it is very much, my book is very much a kind of a study of the towers, not the trenches. I'm very much looking at, you know, global norm making and so on. I think that kind of, that question of how is, even if, you know, legally maybe it's not, you know, having a great impact, how is it being used strategically by actors? And there's some by both, you know, workers and unions, maybe as a sword, or by businesses as a shield and so on. I think there's a lot more work that can be done about that. I mean, certainly, you know, in the Australian context, you see this is the way that kind of unions tend to kind of frame their claims in terms of global supply chains for businesses now, which is interesting. So I think it's, yeah, and it's, I guess it'll be interesting to see whether that is actually providing any leverage, that reframing. I think certainly, you know, the feedback I got from interviews is that unions, you know, workers representatives use that language because it gives them some traction, where otherwise they didn't have traction. But whether that actually translates into any kind of meaningful success, I think is I'm not sure about. On the courts, I think there are certainly cases, and I draw kind of in my book on work that's been done looking at judicial deference to corporate practice, and also on kind of the disciplining power of legal doctrine, how, you know, judges, when they see new concepts, they tend to kind of move them and fit them in concepts that they already know well. And the concern is if we give human rights due diligence to judges early, then they will just do that, basically. They will, or certainly, I would say some do. And there's great work as well being done by Judy Fudge and Guy Mundlach on kind of the various kind of obstacles that judges put in place of workers trying to seek justice. It's called Peeling the Onion, which is a great title and easy to remember, about the various obstacles that judiciary tend to put in place for workers trying to seek justice for abuses in transnational supply chains. I think obviously one of the big spaces to watch, and everyone is watching, is the cases that have been brought in France. There's been a few of them that relate to labour rights issues, but as far as I'm aware, none of them have really been resolved. There are certainly cases, and I talk about Canadian case in my book, but others where courts, and I know there's something in the French context and the Canadian context, in which, not in the context of due diligence laws, but other laws which have been sought, where actors have sought to use the law to hold businesses accountable for labour rights harms in their global supply chains. And the courts have been very willing to basically endorse the kind of private audit approach. And indeed, in the Canadian, you know, context, the judge actually praised the company for going to the efforts that it had. So again, this kind of all kind of brings to my kind of, I guess, concern with placing these kind of questions before the courts at this stage.
Thank you so much. That is all the time we have for today, but I would like to once again thank our guests, Dr. Ingrid Landau and Professor James Harrison, and all of you in the audience today for taking part in this webinar. And before leaving you, I would like to also invite you to our next webinar with Maya K. Davis-Cross on her new book, International Cooperation Against All Odds, The Ultra-Social World. And as always, you can sign up for those at eu-renew.eu. Thanks for joining us today, and thank you very much, Ingrid and James. Hope to see you again soon. Bye-bye.